Yes.
This is the matter of Thomas J. Smokey, DOC number 3422, felony offender. He's serving a life sentence on the charges of simple burglary, illegal possession of stolen things, and simple burglary and theft after having been adjudicated a habitual offender. Is that information, Mr. Smokey, basically correct?
Yes, sir.
Your case has been assigned to Mr. Alvin Roche. Would you please answer any questions he might have?
Good afternoon, Mr. Smokey. How are you?
Doing fine, a little nervous.
You're nervous. I can see it. But sit back, relax, and we're gonna have a conversation, okay?
Yes, sir.
Mr. Smokey, you're currently 47 years old. You're a third felony offender, and you're sentenced as an habitual offender for theft, $500 or more, and you were sentenced to life. Is that correct?
Yes, sir.
You have an extensive criminal history, and you hadn't done very well on supervision. So tell me what was going on.
I was just growing up, sir, and got with the wrong people and made wrong decisions.
And doing those little things got you in big trouble.
Yes, sir.
Now, what have you done to rehabilitate yourself?
I've taken every class that was offered to me. I've tried to do a little rehabilitation on my own in the dorms and stuff with other inmates.
Now, Mr. Smokey, how long have you been incarcerated?
19 and a half years.
19 and a half years, and 12 months ago, you got a write-up.
Yes, sir.
And you were sent to segregated quarters. It was serious enough that you were sent to segregated quarters for contraband. What was the contraband?
Failed drug test, sir.
And 5 months before that, in 2022, you got another contraband. What was that contraband?
Possession of drugs.
Now, I will tell you quite frankly, I understand your sentence and I understand your predicament, but I can't vote for you today because you're still committing disciplinary write-ups, very serious disciplinary write-ups. You have a drug problem. You need to talk to the warden, assistant warden, and see what you can do about that. You have an extensive criminal background. You do poor supervision. You even do poorly incarcerated. It's time to get the train on the tracks and get everything straight. So the next time you appear before this board, you'll be right up free, you'll have substance abuse treatment, and you'll have some ammunition for us to consider releasing you. Warden, would you like to add anything?
I agree with you, Mr. Roche, that we're gonna come up with a plan for him to have more programming and more treatment, and stuff to try to conquer his drug habits and stuff. So I think he need more programming. They froze. Big time. Okay, can't do that. Oh.
It's funny. They froze.
Oh, yeah.
We haven't seen this warden. Maybe once have we seen her?
Go ahead, it's good. Y'all can talk to this computer.
Mr. Marabello.
Computer is.
She can hear you. Warden, can you hear us? We can't hear you though.
Oh, God.
Now we can, now we can.
You hear me now?
We're apparently out. Are we out? Can you not see us?
I cannot see y'all at all.
We're here, so we're gonna continue on, without, just without being able to see us.
Okay, so, I'll repeat what I was, saying to Mr. Roche about Mr. Smokey's, drug, problem. I think that he do need more programming, and we would suggest that he go into, some type of substance abuse, long-term care. So that we can get some help.
We hadn't heard that part of it.
Okay,
I think Ms. Wise has a question of Mr. Smoker.
okay. Can you hear me? Here, Sean, can you hear?
No, ma'am.
Can you hear me now?
Yes, ma'am.
I saw the record where you had been enrolled in victim awareness, and then you got removed due to excessive absences. Speak to that. What was going on?
That's when I got that write-up for the contraband, ma'am, and they moved me to another camp.
Okay, okay, all right, I understand that, I understand. That's all I had, Chairman.
Thank you very much. Now we'll hear from your brother, Frankie Smokey. I don't know if we still have him on, but,
There you are. Okay.
Smokey, can you hear me? Mr. Frankie Smokey, can you hear me?
Yes, I can hear you.
Okay, if you'll introduce yourself, sir, and tell us what you'd like us to know about your brother.
I was just going to say that I'm prepared that if he is paroled to take on the responsibilities of making sure that he does what he's supposed to do, attend AA meetings, get him back on his feet to where he is not offending.
Thank you, Mr. Smokey. Lucky to have you. Mr. Thomas Smokey,
Yes, sir.
would you like to say to the board before we vote?
Since I have gotten the contraband write-ups, I have been in Alcoholics Anonymous, which is the only thing offered to me right now. And I have been write-up free and drug free since then.
Thank you very much. Panel ready to vote?
Yes,
Roger?
Mrs. Logan, based on a general disciplinary conduct that's unacceptable, you had two write-ups in 2022, both for contraband. Both write-ups dealt with illegal drugs, excessive criminal history, and the need for substance abuse treatment. I deny your.
Mr. Thomas, I urge you to stay the course. You're doing well, stay the course, but I deny as well, and I urge you to reapply as soon as you're eligible. But for the reasons stated by Mr. Roche, my vote is denied, but I encourage you to continue to stay the course and reapply when you're eligible.
Mr. Smokey, my vote likewise is to deny. I think you need some strong long-term substance abuse treatment. The board indicates that she's going to assist you in trying to get into that. So I hope that you take advantage of that. And perhaps the next time you'll have a different verdict. Today, your request has been denied. So good luck to you.
Thank you.
Okay, so I wish I could rage about this, and I think maybe I still can. Given a life sentence for really what's a lot of petty theft crimes, now he does have a molestation of a juvenile in the mix, and I don't know how to interpret it. The reason I say this is I did the math, and he was 20 years old when he received that. And he also received it on the same day that they smacked him with like 4 other robbery or burglary crimes. So it just wouldn't surprise me if he was doing a burglary with like a girlfriend who was 16, and they decided to throw the book at him, kind of thing. But I know it's not fair to try to make excuses, and of course 20 and 16 is still not appropriate, but it's obviously different than the roaches that we're used to raging against. Now, still, Louisiana gave him a life sentence, and the crimes were, minor. $500, well, over $500, but basically he had a jury trial. They found him guilty of stealing stuff, and they gave him a life sentence as an habitual offender. And you can see the crimes here. He has June 15th, 1994, for, it doesn't exactly say what. Then he has a 1996 guilty for the indecent behavior with juvenile. But on the same day, as you see, he has the guilty plea for simple burglary, another guilty plea for simple burglary, another guilty plea for simple burglary. So you can see they threw the book at him. I think they gave him, on that one day, October 17th, 3 simple burglaries and the molestation of a juvenile when he was 20 years old. It doesn't seem served much time at all, because on March 3rd, he pled guilty to another simple burglary. So October, that's November, December, January, February, right? So, and so those are like the felonies that they get him with, where then, I guess a few years later, he gets this next thing and they give him life. And I get that, letting him out now, he probably goes right back to his ways, and he does need programs and the whole thing. But still, the idea that Louisiana gave him life just drives me nuts. So here's the crime that he did in 2003, which you might even argue. I mean, I don't know how much jail time he got for his one before that, 97, but that is 6 years later that he gets his next one. So the Poole Lumber Company operated with sales area and a warehouse behind the sales area. In October 2003, they hired the defendant to work in the warehouse. At the time of the offense, the system for returning purchases items in Poole involved the customer taking the materials to be returned to the warehouse portion of the business and obtaining a returned good material slip. This returned good material slip indicated the type of quantity of goods returned signed by any of the 3 workers in the warehouse. The customer could present the signed returned goods materials slip of the sale area and receive cash refund of up to $500. Refunds over $500 had to be mailed to the customers. See right here. It's good money, right? Mike, the manager, reviewed all documents concerning cash refund by Poole. He became suspicious after the relatively large number of refunds given to Katrina Carrier. The inventory records did not support the alleged returns. Further, Manguino did not recognize the signature of the worker alleged receiving materials back from Katrina. Also, May 6, 2004 refund. He notes Katrina's last name was different. Manguino indicated on April 9, 2004, Katrina was refunded for $142.45.20 for material allegedly returned to Poole. Returns. I mean, as you can see, this is like it's they figured out a hack how to print money, and they're like, wow, we can let's just keep getting money. And then the manager's like, wait a minute. I'll drop the link in the description. Thank you, Richard. On May 11, 2004, Manguino had alerted the sales clerk to inform him the next time Katrina. Oh, this was 2004 and 2006. Okay, so to write down the license plate number of the vehicle. Katrina made a purchase of Poole. Manguino provided the license plate. Blah blah blah. They actually brought in the detective for this. And June 14, 2004, he questioned the defendant concerning his involvement in the offenses. The defendant was nervous but denied any participation in the offenses. After Detective Hartzog showed the defendant the document provided by Manguino, the defendant confessed orally and in writing. Isn't that crazy? It's like you would think, these criminals would just learn to just say attorney, but we only see the dumb ones in prison, right? I mean, you get what I'm saying. So participating in one of the fraudulent returns of the pool after Detective Herzog pointed out to the similar, of course, smart ones go to prison too, but it is interesting how they just don't understand that all they have to do is say attorney. The defendant confessed orally and in writing participating in 5 fraudulent returns in his written confession. He stated, I did 5 returns. It was my idea to do it. I got some of the money and she kept the rest. No one else was involved except me and Katrina. I am very sorry for doing it and would like to repay the money. You know, that detective, like, for sure was like, yeah, just write it down. Here's a soda. You know, you want some, you know, here you go. He had no idea that this little paragraph full of typos and everything would end him up with a life sentence in Angola. You can't make it up. On July 9th, 2004, Detective Herzog questioned Katrina concerning the offenses of pool. Katrina confessed in writing. On July 12th, 2004, the defendant advised Detective that the defendant's sister had been involved in the failed attempt to obtain fraudulent refund. It's so funny when they figure this out. They're like, wow, you can get money, man. Katrina also testified in trial that the reference to the fraudulent returns in April. She indicated that the defendant, it's hard for me to understand that this turned into a life sentence. Life! And even when you look at his recorded crimes, it's hard to understand how this could be life. I mean, there's no weapons involved. It's burglary stuff. In counseled assignments of errors number 2, the defendant argues that the sentence imposed on count 1 is excessive because it's not the worst criminal to violate the simple theft statute, and the offenses were not the worst incidents of simple theft. I mean, Louisiana Code, blah, blah, blah. How do they argue that it's not excessive? The PSI indicated that the defendant had at least 20 felony convictions. Oh, okay. Well, and any sentences less than the maximum would allow him to continue his criminal behaviors and cause citizens to sustain temporary substantial loss. Okay, well, I didn't realize he had 20 felonies. I would still say life is ridiculous. Locking someone up for life in this scenario, it's totally different. You harm a child, you take someone's life, totally different. But in this scenario, it's clear that the dude has an addiction problem, and he's also not, except for his freaking molestation charge, which I wish he didn't have. But you've heard my thoughts on that already, and I'm just trying to run through that. That you would just say that this person, you can give him a 20-year sentence. You can give him there's like a 20-year sentence would be pretty darn severe. And so that's why I just don't get it. The court found there was undue risk during the period of suspended sentence or probation. The defendant would commit another crime. The defendant was indeed in correction treatment. Custodial environment that could provide most effectively his commitment to institution. A lesser sentence than the sentence would be imposed would depreciate the seriousness of the defendant's crime. And we have seen so many vile criminals that do the worst to children, that do the worst of the worst in every scenario, and you don't see this sentence. A lesser sentence than the sentence imposed would depreciate the seriousness of the defendant's crime, which is literally found a scheme in returning something. Like, just please. The court also found the defendant had been persistently involved in similar offenses, which went above and beyond the criminal history set forth in the multiple offender adjudication and others. In fact, that the defendant was relatively young, having been born in 1976. There was no mitigating circumstance whatsoever in this case. The court found no reason to deviate from the maximum sentence. Man. It just makes no sense, but what can you do? And you would think this is archaic. You think maybe this was written in like this, appeal came in and I don't know, maybe it was the 60s. maybe it was like back in the medieval times. No, this is 2007. This is like it feels like you could be in a different country. Like this is the type of thing you would see happen in the gulags or in like the internment camps in China, where it's like, oh, you have all these burglaries, life by Angola, nonetheless. Anyways, obviously, I guess it was he had a chance of parole probably because of Act 122. That's a good question. Why is it chance of parole? Probably Act 122. Anyways, that's my blurbs ventings for the day. Thank you for being here, and with that, I'll let you go.